an issue being challenged. Well, what does that require? It requires really quite, you've got to be very, very specific. You've got to be very thorough and exact in terms of the types of petitions being submitted. In addition, there has been a restriction in terms of third-party placement. So what immigration has injected says that if you want to sponsor someone for H-1B, you have to show that you actually control the employment of the foreign national, that you're the employer who is overseeing the day-to-day activities and is responsible for the activities of the foreign national. Well, that's becomes quite challenging to job shops. And actually, it becomes quite challenging to a broad range of employers that use either third-party entities for their staffing needs, or simply have a corporate structure in which they may not have, it's not palpably obvious that they are supervising the foreign national. Again, none of these in and of itself becomes insurmountable barriers, but looking at the landscape, it's things that need to be considered and addressed in terms of the H-1B, putting in an appropriate H-1B visa petition. So, in terms of the requirements, we've talked about the fact that the foreign national needs to have a bachelor's degree in the area of the prospective employment. There has to be the control issues, and you really need to address any type of third-party placements. And in a way, the H-1B is an ongoing contract between the employer and the U.S. government, where you have to explain what the person is doing, where they're going to be working, the terms of their employment, and so on. And to the extent that there are deviations from the original game plan, that may or may not require an amended filing. And that is something which I think you probably need to get legal advice in terms of, positions are organic. You sponsor someone assuming that they're going to be working in duties A, B, and C, but over time, there's a requirement for them to be working in D, E, and F, or whatever the growth is. And sometimes there's kind of this organic growth that an initial H-1B petition will cover promotions and certain changes. At other times, the changes become so stark that it requires an additional filing. But again, that is something which needs to have some rigorous analysis. Yes, please.
What happens if somebody has an H-1B with an employer that gets acquired by another company?
That's a great question. The law is that if there is a total acquisition, so not just of assets, but that the acquiring company becomes the successor in interest, then the H-1B rolls over. If it is something less than that, and one of the things, and I think this really kind of pervades so much of immigration law. You've got business needs and how the business community works, and then you've got a somewhat non-responsive both bureaucracy and the law itself. So sometimes they don't mesh. And my only point is, in the acquisition area, immigration has created a very, very high level of showing that there's a successor in interest, which probably does not mirror how acquisitions are normally made. So as a statistical matter, many, many, many acquisitions, which seem to be a rollover, require requalifying for the H-1B.
And I'll just make a note on that there are ways if you know for a structure. So a lot of the difference is a stock acquisition versus an asset acquisition where you want to avoid liabilities. And there is a way to take your liabilities only for immigration, even if an asset purchase, as long as you affirmatively agree to do that. So unfortunately, as immigration lawyers, we're usually the last to know about mergers and acquisitions. But if you know this is coming down the pipeline or you're buying out a company, it's fantastic to get us talking with your deal lawyers or in that viewpoint, because you don't want to buy a company all excited and then you realize you lose half the workforce because they can't, or you've just incurred an incredible expense to you to now file amended petitions for a whole group of people. So there are ways to strategize at the front end.
Right.
that can help make this easier for you.
Right. Okay. One of the cutting edge issues is you've got this demarcation line between H-1Bs that are subject to the quota restriction, so they're called cap subject, and those that are exempt. And I just want to spend about 2-3 minutes talking about basic concepts of exemption, because realistically, if you can position a case so it is exempt from the H-1B cap, in many instances, that's going to be your key to success. In fact, that's going to be the determinative factor as to whether or not the H-1B is going to be approved. So who and what situations are exempted from the cap? Well, first of all, you have certain employers that are exempted from the cap. Universities, that's the easy one. You're either university or not. Then the law creates an exemption for entities that are nonprofit and university affiliated. And here again, a little bit like the acquisition situation, immigration has come out with exceedingly restrictive guidelines as to what constitutes affiliation. There's this notion of shared ownership, common control. In other words, they've taken Wall Street concepts and engrafted it onto the academic community. So affiliation normally does not involve shared ownership and common control. It's more of a conceptual, philosophical relationship memorialized in an affiliation agreement, and yet that is not usually sufficient in and of itself to show that there's going to be an exemption based on an affiliation. So you've got teaching hospitals and all types of entities that have relationships with university institutions that are still left out in the cold. In addition, there's nonprofit research organizations and governmental agencies, fairly narrow. Then there's also going to be situations in which there's something called concurrent employment. So let's say that you have a relationship with a university or with an exempt organization. If they hire an H-1B, sponsor someone, even fairly de minimisly, 5% of the time, they can file their H-1B exempted from the cap. Once their H-1B is approved, a for-profit company engaging in concurrent employment picks up the cap exemption. So you could have conceivably a 5% employment relationship at the University of Minnesota, 95% employment relationship with a cap normally cap subject employer, and that cap subject employer picks up the exemption from the university. And again, this is something a little bit analogous to what Deborah's saying, with some advanced planning, with some communication, that might be something that can be considered. In addition, depending on the nature of your business, there is an exemption if ABC company, for profit, hires someone, but the foreign national is working at a qualifying exempt institution, like a university, perhaps in a lab, perhaps on the physical premises of the campus, and you can show that the foreign national is contributing to the educational or research or scholarly mandate of the institution, then that would also be conceivably cap exempt. But all of these, it's a fine line on walking through to determine cap exemption. But again, I want to stress, this in many instances is going to be the determining factor if an H-1B gets approved or not. Okay, want to talk any questions on H-1B? Because again, that's the workhorse of the system. Okay, I want to talk just a couple minutes on F1 students. So the United States is still actually statistically by far the most desirable country for foreign students to come. And the predominating visa that lets foreign students come to the United States is an F1. And it says that someone can come and study on a full-time basis. It does not create in and of itself employment authorization. But here you've got students acquiring really interesting professional skills, academic skills, which conceivably are very valuable within your own organizations. Well, there are a couple instances in which an F1 student can work. Number one, there's something called CPT, which simply says that you have a position that the admitting university recognizes as containing educational content, and that the university will grant internship credit. So it's kind of an internship type program. The nice thing about CPT is you don't have to do just about anything. All of this is done through the university, through the Foreign Student Office. Then there's a program that says normally it's following graduation. Once a student completes his or her studies, there's something called optional practical training, or OPT, and many of you, I'm sure, have hired students under OPT. And what this says is that the United States immigration authorities give employment authorization in order to gain real-world experience in the area of the academic studies. So it's a work card initially granted for 1 year, which can give first of all, a student the ability to get a job that illuminates their academic training. But number two, it's a great way, again, for you to hire someone with minimal involvement because they already have an employment card. Now, the advancement we've seen over this past year is that effective this past May, there's an expanded program, and it says this: if a student graduates, holds a degree in a STEM discipline, science, technology, engineering, and math, they have a potential for not only getting the initial 12 months of optional practical training, but 24 additional months of employment authorization. And that's called STEM OPT. The nice thing, when you think about it, is you've bought yourself 3 years of employment authorization where you can employ someone, which number one can create a window of time to sponsor them for H-1B. You can go into the lottery a number of times, therefore, statistically increasing your possibility of approval. Or in many instances, you could even sponsor someone for permanent residence successfully within a 3-year period of time. But STEM OPT has a couple hiccups to it. Mainly, two of which I want to just cite very briefly. Number one, you've got to be an E-Verify employer. So the E-Verify aspect only goes into effect on STEM OPT, not for the regular OPT. Number two, and it's not a fiction, but it's a reality that in order to sponsor someone and gain someone's employment authorization under the STEM OPT program, you have to develop and implement a training program. So there has to be this underlying structured element of training within your own employer situation. It can be done. You just have to kind of conceptualize the duties of the foreign national to incorporate some type of a training component. But the STEM OPT can really be very, very powerful. Please. Yes, but that is correct. But the attainment of employment authorization allows them to get a Social Security number. So they have the documentation allowing them to get the number. Correct.
But it's just a temporary one, or it's actually?
No, well, you know what it is? That's a great question. The number itself becomes current. So once someone gets a Social Security number, that's their number. It's just that it's a little bit like a spigot. It turns on and off. So they'll have the number, but it becomes invalid if they lose their employment authorization. Please.
So the CPT is all sort of student-driven and university issued.
Correct.
With the OPT, the
No. And actually, it does not know, because what happens is the student gets the permission from the foreign student office. So they are basically registered in the immigration system. It's called SEVIS, as being eligible for OPT. Then they file to the Immigration Service to get their employment card. Once they get their employment card, they can walk in and they have a document allowing you to complete an I-9. So when you think about it, your involvement is absolutely de minimis. It's a little bit more under the STEM OPT, because you have this notion of having to create a training program. Yeah.
That's it, right? I mean, like, other than, like...
Yeah, that's pretty much it, yes.
Okay, yeah.
Okay? You want the clicker?
Yeah.
Oh,
You want to?
you just skip over.
Okay. Just to tell you, there isn't, on top of that, Katie, all you have to do is there's also an annual review you have to do of your employee, and you do have a compliance rule. So if the person left your employment, you do have to notify the DSO that they're no longer employed with you. So it does create a little bit of extra work from the employer, but pretty de minimis. So, okay, here we go. Very good.
So I will talk about alternatives to H-1B. Like Bob said, the new STEM OPT rule definitely relieved the stress for a lot of companies who are trying to recruit and maintain foreign workforce, and who can't get an H-1B through the lottery system. There are definitely a number of options for candidates, and we have to assess their eligibility for any of these on a case-by-case basis. And oftentimes when an employer finds out that, oh, I have, say, 50 or 100 employees who didn't get into the lottery, now what do we do? And a question that we're often asked is, can we bring them in on a business visitors? Or rather, we're sometimes asked, well, we have this guy here on a B1 visa. Can we hire? Can he work for us? So the first thing to emphasize is that business visitor visas, or for people of certain nationality, they come in under a visa waiver program, so they don't actually have a stamp on their passport, and they enter with what we call ESTA, electronic system of travel for travel authorization. So for these people who are categorized as business visitors, they're not authorized to work in the U.S., so they can't be paid or receive any compensation from within the U.S. And the time period that they are allowed to stay in the U.S. is temporary. So for B1 visa holders, that's up to 6 months. Sometimes it's shortened to a month or 2 months, depending on the CBP officer at the border. And for ESTA visitors, it's up to 90 days. So for business visitors, the type of activities they're allowed to engage in the U.S. is limited. It's the typical business visitor activities like attending meetings, going to conferences, trade shows, and conduct contract negotiation, and that type of things. So if a good question to ask yourself when you think that, well, maybe this person is going to do something that crosses line, is to ask, would I pay a U.S. worker to do type of work or type of activities that this person is going to engage in the U.S.? And if the answer is yes, then you probably need work authorization for the person. And also, what's the risk for the company and for the business visitor for crossing that line? So one, the visitor themselves, if the CBP or at the consulate, they look at his travel history and realize that, oh, this guy has been traveling to the U.S. quite often. He just spent 6 months here, and he went to Canada for 2 days and come back, and he's trying to come back in. There's a good chance that at the border they're going to suspect that he's actually engaging in employment in the U.S., and they might either turn him away, or they might give him a very short period of stay for this particular entry and tell him, listen, you need to get the proper type of visa to come in next time. And for companies, sometimes we see that certain consulates might flag a company if they see that this company is bringing in an awful lot of business visitors every year. And that might jeopardize your future true business visitors who are trying to get a B1 visa to visit you. So what are the good options that actually will allow a foreign national to work in the U.S.? The first one we'll talk about, if I can figure out how to use this.
No, you have to use the clicker, Deborah.
Which one? Oh, it has to. Oh, okay. So the first one is called J1. A lot of you guys might have heard of it in the context of a cultural exchange student, especially for people who work with universities. This is not limited to visiting scholars. For companies and businesses who are trying to bring in a foreign national who has a foreign degree and work experience abroad, if I can speak today, this might be an option for you. So there is a really informative article in your material today from a American Immigration Council about J1, so I won't spend a lot of time on it. The things that I want to point out is that for J1 trainees or interns, they have to have a foreign degree and work experience or work experience abroad. It doesn't necessarily work for someone who's already in the U.S. who is running out of OPT. And when you apply for a J1, we have to develop a training program that encompasses all the activities that this individual is going to engage in with your company. And there is and if we get it, it usually gets 12 months or 18 months for the individual to work or be trained at your company, which sometimes wins the candidates a couple of some time, and they might be able to try for another H-1B visa next year. One catch for this category is that some individuals from certain countries and in certain fields are subject to a 2-year home residency rule, which means that once they complete their J1 program, they have to leave the U.S. and spend 2 years in their home country. This rule is put in place to actually protect high-skilled workforce for foreign countries. So the Department of State actually negotiate with certain countries to come up with a skill list. And they put it up so when you have someone who you're considering to get a J1 visa, we have to look for the skill list for the country that they're from and check whether his occupation or his area is on the list. If it is, then he is or she is subject to the 2-year home country rule.
If I can just put one additional word in, J1 is in many instances quite overlooked, but it can really be very, very useful because there's a level of flexibility to it. So, for example, I mean, if you've been to Valley Fair, if you've been to Disneyland, and you notice people speaking with foreign accents, a lot of them are J1s because there's a program that lets that type of exchange. And J1s go everywhere from, people administering the rides at Valley Fair to nuclear physicists at Harvard. I mean, it's this wonderful kind of malleable visa status. I'm going to just put in a plug. Years ago, I wrote an article, and it had my favorite title of any article I've ever written, and it's called "Zila Gets a Visa." And if any of you remember the old Woody Allen movie about a guy who just changes into his environment named Zelig, I thought it was really a cute title for the J1 article. Okay.
Quick question. Is there any limitation of what type of company can utilize J1s, H3 and everything else? You have to have a certain number of employees or revenue or anything?
No. What happens is the
Actually, there are. So you need to have a sponsoring agency.
Right.
And the sponsoring agency may have rules on size limitations. If you're a small company, they have certain revenue, they have a certain number of employees. If you don't meet their threshold, they may do a site inspection. in order for you to qualify to be an employer that can have sponsored Js. So it really just depends on the type of program you're using, intern or trainee. It's very specific from that avenue.
Correct. So the hierarchy is the Department of State runs the whole J1 program. Then they designate appropriate J1 sponsors. So they kind of farm it out. And it could be an individual company, in which case you have to have, I think it's 25. There you do have to have certain sizes in terms of the volume of your J1s. Or, as Deborah said, they kind of deputize other agencies, which in turn is responsible for the integrity of the end user.
So this gentleman mentioned H3 trainee visa. Even though it's also called a trainee, it's very different from J1. It's not reserved only for people with a foreign degree and foreign work experience. It's also employer-sponsored, more like a traditional H1B visa. So for this type of visa, it's for maximum for 2 years, and the amount of time an individual spent in H3 status would count towards the 6-year limit for H1B if they end up getting an H1B in the future. So for this type of visa or status, we also have to develop a very comprehensive training program for the individual. We have to be able to make a case that the content of the training is not available outside of the U.S. So it could be that the person is learning about a technology that's only available in the U.S., a type of processing, a specific kind of machine, or even U.S. law and regulations that's not available outside of the U.S. As an alternative to H-1B, it's usually more useful for companies that have a significant international presence. The reason is that we have to be able to show that the training in the U.S. that you provide for the candidate will be beneficial for them to pursue a career abroad. So if you have, say, international presence, and the plan is for this individual or these candidates to go to a different location for your outside of the U.S. to work for your company, then this would be a very helpful. This might be a category that we can consider. And as the slide says, educational component is central because this is supposed to be a training program rather than work. So the USCIS will look at how much time is this program involves lectures, involves observations, how much on-the-job training it is involved, and it does not allow actual work, but only on-the-job training that's incidental to the education component. Oh, there we go. All right, so next one. Is O1 extraordinary ability. And we have a live example here in our audience today, so I feel like I don't really need to say much about it. If you have a candidate who's like Struan, or as successful as he is, then think about O1. If you have a candidate who's half as successful, we might still be able to make a case.
You want to say Frederickson did miracles.
So this category is intended for people who are well known in their industry, who has made significant contributions to their company, to the industry they work in, or even on a national or international level. So it doesn't have to be people in the business world. It can be scientists, researchers, even artists and athletes. Of course, with the new rules for STEM OPT, a lot of scientists and researchers might not need to consider this category. But if you have someone who doesn't fall under the STEM OPT rules, then this would be a great place to look. And it's usually what we consider someone extraordinary ability. We look at, has he or have they done something significant for their company, significant for their industry? Has their work been influential? Have they published articles, or have they been interviewed or quoted in the public media? Have they won awards? Are they holding leadership or critical roles in the organization they work for? Those type of things. So, and sometimes this is a category where we can definitely be a little more creative. And Deborah's nodding because she's very good at putting in the creative touch. And we have definitely brought some candidates to the U.S. under O1 status who you might think at first as a stretch, like executives or managers for startup companies that are not very well known. And Deborah probably can give more examples. So this is definitely a great place to look.
I think she means I'm good at BS, so let's...
So the last type of visa that I'm going to talk about, a lot of you might be very familiar with this, especially for companies that have international presence. It's L1A or L1B for international company transferees. It applies to individuals who are who holds executive managerial positions, or an employee who has specialized knowledge about the company's business that's not very easily transferable to other employees. This type of visa, of course, we will look at it if you're bringing in a foreign employee who has worked for your company, your affiliated parent or subsidiary companies abroad for at least 1 year out of the past 3 years. But sometimes if you have a candidate who's recruited from the U.S., but they either run out of H-1B or run out of OPT, and if it makes business sense, sometimes we would recommend sending this individual to your affiliate or qualifying entity abroad for a year, and then bring them back on an L1 status. So there is similar to H-1B, L1A candidates who. So these are people who are executives or managers. They can stay in the U.S. for up to 7 years. And for L1B, they can stay for up to 5 years. But there is an exception for that rule, which is for individuals who travel quite a bit. If they, especially for executives and managers, if they only accumulate about less than 6 months in a calendar year in the U.S., then they're considered intermittent Ls, and they're not subject to the maximum year rule. There are, so the process of getting Ls, of course, it's very similar to H-1Bs. You file a petition to the USCIS first to qualify them, and then the individuals usually will need to apply for an L1 visa abroad at a U.S. consulate. There's an exception for Canadians who don't need a visa to come to the U.S. So what they do is they bring their materials, they apply directly at the border before they come into the U.S. There are also a type of L1 called L1 blanket petitions. This is for international companies that have very significant presence in the U.S. And what it does is that you apply to the USCIS without linking the petition to any particular candidate, and you ask the USCIS to approve your company as a qualifying entity. And then in the future, when you do have candidates from your affiliate or qualifying entity abroad who need to come in, they will directly go to the consulate to apply for an L visa under the blanket visa approval that you already have received. So with that, I'm passing this to Deborah.
I have a clicker. And I will be short. I've been told to be done in 10 minutes, so I'm holding you up for a break. So I will talk fast. So I'm talking about treaties. So we had mentioned before when nationality matters. So you're always told, you can't discriminate about national origin, but I'm here to tell you it's actually very important where you're born, because your citizenship can actually give you the right to work in the United States. You have a benefit that others don't. If you're Canadian, if you're Australian, if you're from Mexico, if you're Chilean or Singapore, you are lucky because we had a trade agreement with your country that's giving you additional rights. So I'll just talk briefly about them. So when you're screening candidates, it is helpful to know if they're from Australia, because while there is a limitation, they have never reached their cap. And so they can apply directly at the consulate for what's very similar to an H-1B, professional worker, pay the prevailing wage. They can apply directly at the consulate. We've had excellent success. In my opinion, it's pretty straightforward. They have revised the rules to make it a little better. When they created this category, I say they messed up. They forgot to include a provision that you could extend it in the U.S. to continue working. Everybody else within the regulation for most non-immigrant visa categories, when we extend your status, while it's pending and taking forever, and our later talk will talk about why it takes forever, you have the right to continue working in the U.S. for another 240 days. They forgot to include the E-3s. So what did that mean? You had to get on a plane and fly to Australia, get a new visa, and come back in. That would also include your kids and family. Finally, they did correct that this year, so they now can file for extensions in the U.S., which is a big plus. Chile, Singapore, again, very similar. What's also unique about is allows for a spousal work authorization. So important. I don't know how many Chilean Singaporeans you're able to recruit, but something to think about if you get lucky. Like I said, quick. NAFTA. I'll talk a bit more about NAFTA because this is something we're filing constantly, and I think being in Minnesota, we get a lot of Canadians, and we get a lot of qualified candidates from Mexico with professional degrees that companies are eager to have. So a few things: you have to be Canadian or Mexican citizen. Spouses don't, so they can be from anywhere and still come in as dependents. There is a list of occupations in NAFTA that's published. You have to fall into one of those occupations. Let's remember when NAFTA was passed, because even I can think back at least 20-some years ago, how many new jobs and occupations I've created that didn't exist when NAFTA was around, right? Pretty much our entire IT industry. So while you may have a job and you're looking at it going, well, my job says software engineer and you only say engineer, does it qualify? We would argue, hopefully, yes. So the idea is to craft your job description, create it to fit into one of those occupations. We try to be as creative as we can with what the legal parameters require. We've done one for an audiovisual sales marketing with a degree in architecture to fall under architecture because she's going to market it in sales to architecting companies. I've done an interior designer for Ethan Allen. She had an Etsy blog and website for years, and she had the qualifying experience. So you can be creative in who can qualify for these occupations. So don't get scared off if you don't initially see it in the list. There are some avenues we can still use to make that work. Canadians can apply directly at the border. And if you're unsuccessful, say you have a tough border entry, the good news is you can try again at the service center. So you actually can have two bites of the apple. If you weren't able to convince Customs and Border Protection, maybe you're going to have a better shot with the U.S. Immigration Service. So there are ways to kind of keep fighting these types of cases. For a Mexican, they do have to file at the consulate. What's nice is they got rid of, you used to have to file the I-129 form. They got rid of that. It's similar package that you prepare for a Canadian, except they have to go to, it's almost a 2-day interview. The first day of biometrics, the second day they actually have an interview at the consulate. For Mexicans, the harder part is they only get a 1-year visa. And why is that problematic? Is because when they need to renew their visa, they have to go back home. We also see a lot of issues with Customs and Border Protection making mistakes. So even though their visas for 1 year, their work authorization for a TN is 3 years. But what we see coming in is they limit it to 1 year. And so those are things to watch for and monitor. But good news, there was just some minutes that CBP released that said they're now going to have a proper procedure for documenting if you work a TN for multiple employers, that is going to be allowable. Maybe none of you want to tell your employees that, but say you have a part-time TN worker and they want to work for someone else, they can have a TN authorized to work for more than one company. They also have now stated that they can enter on their old visa with a prior company with a new letter of employment to change employers. That's new. It's one of those things we had always been a little hesitant to advise on. The hard part is if your visa is only good for 1 year, you may not always have that possibility, but it's something to keep in mind. So if you're worried about the H-1B cap and you're still looking at recruitment, recruiting for Canadians and Mexicans is still a good option. Ease. This is helpful if you work for a company that is owned by either the majority owners are from a treaty country, so say they're owned by people from the UK, or your parent company is a UK company. That allows you to send over anyone who's also of that same nationality into the United States. The catch is that we have to have a treaty with that country. Of course, the most populous countries in the world we do not have treaties with. There's nothing with China, nothing with India, nothing with Brazil, but we do have one with Iran. So go figure. It's something to keep in mind. Es are filed at the consulate. You can do the U.S. Immigration Service. I would say 98% of the time we file at the consulate because you could get up to a 5-year visa. That's huge, right? What other visa category can we think of? You get 5 years. But what happens when you enter the U.S., they give you 2 years of work authorization. But if you travel the day before it expires and come back in, you just got another 2 years. So it's extremely useful. It's only for those who are executive managers or essential workers of the organization. And you do have to have that qualifying treaty. Spouses can work, so it can make the integration of the family much easier because they're going to have work authorization for any company. And it's really good for entrepreneurs, people who want to do startup. I've done a lot of MBA grads who have great ideas for starting up a company. And if they are lucky enough to have an e-treaty and some type of angel investor or to help them get the startup funds, that may be enough to get them on the ground to start exploring their dream. You can have minority investors. So we've had people with U.S. citizen friends who they want to own the business with them. So you can have a combination as long as we show the control of the entity, which is easiest done through 51% ownership, is governed by that foreign national. So great option. To keep in mind, the TN and the E, actually all of these treaties have what we call temporary intent. They don't have dual intent, which you see for the H and L, which means they are not supposed to also want to be going down that green card path at the same time. It's a conflict of intent. And so at the end of the day, a lot of people do want to go down the green card path. So that's something to work out when the timing is right, because it may require them to be grounded in the U.S. for a period of time, but it's still a possibility. H-2s, we do a lot. Lon does a ton of these. And these are going to be for what I think really temporary workers. So they can only work for you for less than 10 months a year. We have a large practice with this with the hospitality industry, landscaping industry. So these do not have to be, these could be unskilled workers. You could require someone to have a high school degree and the ability to lift 50 pounds, but you need 100 workers for summer because they need to plant, 10,000 trees, and this is your growing season. This would be the type of possibility. You need housekeepers. It's a complex process. It's almost like filing for a green card. You have to conduct recruitment and show you can't find U.S. workers. You have to file with the Department of Labor to show you're going to be paying the wage they tell you to pay. There's a set period of time before you can start the application to when you can file the application. You have to show that you've told all your other U.S. workers who used to hire for you that the position's open. You have to pay for everything. You pay travel costs. You pay their airfare costs. You pay for their trip over. You pay for their trip home. So it's a big investment by the company to do an H-2, but it's also, there's only 66,000 visas a year for this category, and they're also always used up. What does that tell you? We have a tremendous need also for unskilled labor, and many industries have a hard time recruiting. And so this is a very solid avenue. What we found is a lot of people had used that J1, the summer program that Bob had mentioned, but it turns out it's hard to train workers every single year, right? A whole new skill set. If you could get these same workers to come year after year, or you could keep them longer and maybe expand your duties, it's worth the investment. And so that's what we see come from a lot of companies. Okay, I'm almost done. Green cards, how does this fit, right? I'm teasing you. I just said this is all about non-immigrants. Well, what we talked about is sometimes none of these options are going to be a fit for you, and you want this candidate. We may have to either ignore the non-immigrant visa category and go right to a green card, or when someone's here on a long-term OPT and STEM OPT is look at trying to get the green card as fast as possible, as long as they're not from India or China, because not because I'm discriminatory, but because they're subject to a very long backlog, because that's going to be the fastest way for you to keep them. And at some point, it may be less expensive than trying for an H-1B year after year after year. So things to keep in mind. And then finally, don't forget the spouses. So for H-1Bs for up until a year and a half ago, that was it. H-4 spouses had no ability to work. And what they've done is created a path for spouses of H-1B workers to gather a work authorization document if the H-1B beneficiary has an approved I-140. So really, this is impacting those in lower preference categories, beneficiaries from India and China who are subject to these backlogs, because we'll tell you eventually it could be 15 years for some people, up to 30 years, which is insane, but their spouse cannot be there if their marriage lasts that long, they deserve to work, right? So this provides a path where they can actually get a work authorization document because they're not able to file that adjustment of status, which would normally get them there. It's also useful if you have two spouses working on H-1Bs and one gets laid off. It can give that added safety net where the other worker could get a work card if one of them had gone down the green card path. L2s, E2s, again, I bring that up again, a benefit for these categories of spouses can work. And I bring up TPS as a humanitarian grounds. Recently, with Nepal, with Syria, we had a lot of high-level professionals and a lot of foreign students, I'd say, in Minnesota from these countries who, because of the terrible earthquake and the ongoing civil war, they're able to apply for temporary protected status, which allows them to get a work card. It's at no cost to the employer, but it's something to your workers may come up to you or you may see this that can give them permission to be here. So.
Great, good job. Never can always take up the last talk. Yes, we're going to take a 10-minute break instead of 15 minutes. Come back at 1:45, and I just want to reiterate, don't forget the spouses. Drew made a really good point about that today, and that's something, that's something really to remember that can really drive success in the immigration staff. So thanks. Come back at 1:45. And that don't go away.
the slide thing? The PowerPoint? You have to do it with this, she said.
Okay.
Here you go. You can go on past me, go closer to Lauren. Do you have water? I don't think anyone's used this one. Go for it.
We're gonna, don't worry about anything. I'm cutting the time. Trying to catch up. But you just go through what we discussed. Okay.
Yeah, I can talk faster or drop stuff. Don't worry about it.
How do you want me to introduce you?
What did you say?
How do you want me to introduce you? We don't really have titles at our company, so we're all I'm HR. I'm the only HR.
Just use your name.
Lauren.
Yeah. Don't refer to her as butthead.
Save that for after.
Do you have water, Lauren?
I do, yeah.
Okay.
Oh, I'm so cold.
It was really
It's
cool.
freezing. I'm just shaking. I'm so cold. Hey, these on.
No one's in here anyway.
These are off. Why? What would you rather have?
I didn't know it's Friday that we
Oh.
They weren't like wrapped like that. I've been a couple of weeks.
You mean like a hot one?
or, you know, no, just like
Oh.
that's what happens.
So where'd you get this? Where'd you get this last minute? Where did you get this last minute? Yeah.
I know it's me.
Well, yeah, but I think they were fine.
Where did that go? Well, it's like the air coming from somewhere here because I was sitting right there and I feel it. It's just whenever we have meetings in these conference rooms, it's like you freeze. I don't know. It's like some people here, you know, keep extra sweaters in their office to wear to the conference rooms. It's like, why? It's like it's costing them more money to keep it that cold. Look, and our air conditioning's all closed. We can see the screen. Yeah, I don't know. It's ridiculous. But it's freezing. Ooh, he had a good idea. He got something hot. I know.
That is
I wonder where that is.
I think it's out there. I think they have coffee and tea and stuff.
If you want something in a few minutes, you can go in. He told me to wear these, but I can't see it without it. And
Did you go print off bigger? No.
No, and I can't see the people with them. So I'll be looking over or just making
Turn
everybody.
all the way down at the
No,
end of your
either
nose.
that or everyone will just be blurry. That's probably the way I'll have to do.
So you work with Lon's team then?
I don't think we don't have teams.
Oh, so, okay. So you're
It's
just in
just,
immigration.
yeah, what happens is we typically work with certain companies. Okay. And they kind of do it that way so that you become familiar with the person you work with or two, and vice versa, and you get to know each other and work together. And so, and then you work with whatever lawyer works with those companies.
Gotcha. Okay. Very cool.
And so you just kind of get, I've been here for 11 years, and I've been working with a lot of the same companies I started with.
Okay.
So,
Now, do you have is it like, is it get broken off by size of company, or does it matter? It's just you.
no, it would get divvied up. Oh, you should grab a name. We have name tags apparently. Just here. No, right there, Julie. There should be one for you. It will get. You don't have one? Come on. Well, then I won't use mine.
Oh, you're yours.
I don't care. It will get divvied up depending on the size of the clients you have. Like, I have one really big client. I don't think I could do two that same size. Yeah. So I have, and all mine are corporate clients. So I have others that are kind of medium size and some small.
Gotcha.
So you have to divvy it up
It's
that
work.
way.
It's more workload. It's not company size.
Right, and it's not industry, it's not, and it probably depends on when we get a client, you know, who's got time, who can take this client.
Gotcha. How many do you have total with immigration lawyers and staff?
You're gonna
I
make
also
me
work with
count. Okay, just let me think here. 6 attorneys. 1, 2, 3, 4 secretaries, and okay, 1, 2, 3, 4, 5, 6, 7, 9 paralegals. I think. I'm gonna keep going, so I have to think of everybody's faces or go down the offices and count.
Yeah.
Come on, somebody pump in the heat.
I know.
Okay, Mike.
Oh.
Lauren does not have a name tag. One of those. So I didn't put mine up either.
No, jeez.
Yeah.
You guys can put yours up.
Lon, can I just say, whoever decided to have all of us go after, what's his name? Strom? That was a bad move. Because that was such a good talk. And
Isn't he good?
yeah.
I love him.
And this is nothing like that.
I know.
We're going to have to be energized.
Oh, we are. That's what I was going to do. I was going to get up there.
We have to. Otherwise, it's like this.
Good afternoon. We're going to start soon. So if you can get your treats, we don't mind if you eat when we speak.
We have treats. Huh? We have treats?
We have treats. You didn't go? You have a minute.
1 minute, run.
I'll wait.
All right, we're going to start soon, and we're going to try to catch you up in terms of our schedule. So, again, if you have any questions, please write them down on this piece of paper and pass it to us, and we will make sure we answer it at the Q&A session. If we don't get to it, we will definitely follow up with you personally to answer your questions. But in order to keep the agenda moving and be respectful of your time, I'm not going to take questions, and so please forgive me for that too. So we just talked about non-immigrant visas, and we're going to change the framework for the next 2 sessions, which will be on immigrant petitions. How do you work with your foreign employees to help them get lawful permanent resident in the United States? And our session today will be focused on the PERM labor certification process to get a green card for a foreign national employee. And before I start into our session, I do want to introduce my co-speakers. I'm Lon Huynh, a partner here in the immigration group. To my right, immediate right, is Lauren Coleman, who is Director of Human Resources at Concord, USA. We've worked together for many years, and I'm very excited and thrilled that she can join us and share with you her personal experiences working with us and working with her foreign employees. To her right is Julie Tennum, who is one of our senior paralegals, and Julie and I are partners in crime in regards to the work that we do together and also the partnerships that we have with our clients. So I'm thrilled to have these two individuals here with me today to share with you their perspectives. The title of this session is called Teamwork, PERM Cases and Strategies. And when we start the green card process for any foreign national, it usually starts not only with us as your legal counsel, but it's really a team effort in working on preparing the green card application, but not only the green card application, it starts much earlier than that. So what I'm going to discuss with you today, along with Lauren and Julie, is about the most popular form of obtaining lawful permanent resident for a foreign worker, the permanent the PERM, the Permanent Labor Certification. And it's not just a filing of one application, it's a filing of a couple of different types of applications with different agencies along the way, and we're going to give you an overview of that. But then we're also going to discuss the strategies that are really considered and discussed among the team when we undertake the green card sponsorship process, and discuss some of the issues that may come up that you may face if you do sponsor a foreign national worker, and how you can address some of those issues before you get to a stage where it may be too late and invest in an employee and not realize that some of the issues that may have come up later could have been addressed earlier. So the team consists of the employer, the immigration professional, as I have up on the screen, and the immigration professional can be your HR, your legal team member, or your recruiter who is responsible for the immigration matters that arise in your company. Then you have the foreign national employees manager also as part of the team, along with a foreign national employee. And from the legal team, it's usually a lawyer, such as myself, and our paralegal. All of us together work on the green card process to get to that ultimate stage where your foreign national employee will finally have peace of mind that they're not going to be deported, or that they can remain here and create a future for their family and in the long term, and that it's not just a temporary assignment. And we all work together to make it happen. Obtaining lawful permanent resident in the United States is a difficult process. It's not easy if you don't understand what needs to be done before you pursue the options that may be available. In order to get a green card in the United States, you must have an approved immigrant petition. It's an I-140 immigrant petition. And the PERM labor certification process is one where, in order to get to that I-140 immigrant petition, you have to get a certification from the Department of Labor first to document that there are no qualified, willing, able U.S. workers to fill this particular position before you can file the I-140 immigrant petition. Once the I-140 immigrant petition is filed or approved, depending on whether a visa number is available, the foreign national then can apply for the I-45 green card application. And so this is just a chart or a diagram of the process, I do want to share with you that in your materials, we do have a flow chart that really outlines in details the various steps involved with getting a green card through the PERM application and exactly what each of our roles are, the paralegal, the attorney, the HR, or the recruiter. So when you have a chance, take a look at it. As I mentioned, once you file a PERM labor certification and it's certified by the Department of Labor, the next step is to file a I-140 immigrant petition. If you look at the diagram here, if there is a visa priority date that's current, the foreign national can, at the same time that you file the I-140 immigrant petition, file the I-45 green card application. If not, then you just file the I-140 petition, and they would have to wait. If you're an Indian national, it could be 10 years. If you're a Chinese national, it's a little bit less, but it just depends on what the job qualifications are and the country that the worker is from. So what are some of the issues that you need to consider when you're applying for a green card for a foreign worker? First, the way that you first determine whether you need to do it or not is usually we will contact you if we are assisting you with, if we assisted you with the non-immigrant options, then we usually docket our system to contact you before the time limitation on their non-immigrant visa. So if they're in H-1B status, for example, they can only be in the U.S. in H-1B status for up to 6 years. And we would contact our employer probably no later than the end of the 4th year of the 6-year limitation to start the green card process. We actually have established a policy on our team that we contact you within after 1 year of the foreign national being in the U.S. or working for you in H-1B status or even in L status to determine whether you would like to pursue lawful permanent resident sponsorship for the foreign national or not. And the reason we do that is really to the visa backlogs that I just alluded to before. And there is a line. You have to think about the fact that we're not a country where we're opening the gates to everyone who wants to come to the U.S. We have specific number of immigrant visas that are available, and then they're divided up among countries. And so there are lines of individuals who are waiting for years, or if you're not from India or China, it's a much shorter period to wait for an immigrant visa. And so you have to take that into consideration too when you determine whether you want to sponsor a foreign national for a green card, is how much time do they have left in their non-immigrant status. If they're here on an L1 intra-company visa and they're a person of specialized knowledge, so you can't bypass the labor cert because they're not a manager or executive, and then you need to start the green card process for them probably almost immediately when they come into the U.S. in specialized knowledge status, because depending on what country they're from, it could take 18 months, like I said, to 10 years before they get to the stage where they can get the green card. So that's part of the strategic discussions that we have with you as an employer when we look at all the options available to help maintain that employee here permanently. Another factor for you to consider in terms of sponsoring an individual for a green card is because of the visa backlogs, we have a lot of foreign nationals moving back and forth or to different employers. And if they ran out of their H-1B visa and they had an employer who sponsored them for a green card, and then they move to you to work for you in H-1B status based on the I-140 immigrant petition that their employer obtained, You may want to consider starting the green card process for them immediately in order for you to have an I-140 immigrant petition that you can rely on to extend their H-1B status in the future if you need to, instead of depending on another employer's I-140 immigrant petition for them, okay? Another reason to start the green card process is if you don't have any other options to hire them immediately. Deborah mentioned this earlier, where if we can't get an H-1B petition for a foreign national, part of the discussions that we have now with the employer is, would you be interested in starting the green card process immediately for the foreign national, especially if they're here on OPT STEM, which means they could probably be here for a total of 3 years total after they graduate. It may be a good idea to start the green card process immediately for them, because right now it can take 18 months to get through the Department of Labor, and if they're not from China or India, at that 18-month mark, you can probably file the you can file the I-140 immigrant petition for them, and they can apply for the green card, the I-45 application at the same time that you file the I-140 immigrant petition. So that is a option that a lot of employers are considering because of how difficult it is to get an H-1B visa now. And then if there aren't any time pressures, then it's up to you as an employer as to what you establish as your policy to start the green card process. And in our materials, we have for you guidelines to establishing a corporate immigration sponsorship policy. And it outlines some of the questions that you should consider when you draft a corporate immigration policy. And I encourage you to look at it. We've worked with a lot of companies to work on that corporate policies, and I think it's always a good idea. But Lauren, can you share with us what some of the issues or elements that you consider when you're trying to figure out if you want to sponsor a foreign national for lawful permanent resident? How do you decide and to process for an employee?
Sure.
Can everyone hear me? So we kind of take a backwards look at it. We start from, most of the people that we sponsor are from India. So when we're looking at sponsoring someone in a PERM status, we kind of know that it's going to be around 8 to 10 years before they're going to get that status. So we kind of look at the long picture of 10 years from now, where the relationship, the employment, making sure it's beneficial for both them and for us. When we're committing to any of one of our employees, for that long of a time, we just want to make sure that we're on the same page. We're working with, we work directly with Lon to make sure that it is the right move for everyone.
So the next question that we often address after we make a decision that, okay, our client would like to sponsor this foreign national is to talk about the fees. And it's pretty straightforward. The employer has to pay for the PERM legal fees and administrative fees. For the I-140 immigrant petition and the I-45 petition, that is discretionary, meaning it can be covered by the employer or the employee. Now, an issue that may come up is who's responsible for the fees for the dependents, for the family members, and how do you deal with that, Lauren, in regards to the fees?
So for us, we predominantly just 100% sponsor the employee. With the dependents, we give them the access to work with our attorneys so their cases can collide, but we don't have them pay any of the fees or any of the, any cost towards them, but we do require that their dependents are paid for by themselves.
Okay. Okay. And again, this is something that employers may want to consider including in their corporate immigration sponsorship policy in order to make sure that their practices are consistent across the board. And we have found that there's just been a mix. Most employers will cover dependent fees, but it's not unusual for an employer to say, no, we won't do that. All right, so let's talk about the PERM requirements now. We've gotten the fees out of the way. We know what our strategy is in terms of we're going to pursue the green card process through the PERM application. The PERM application overall is really a filing with the Department of Labor where you, the employer, must test the labor market in order to determine whether there are qualified, able U.S. workers. The PERM position that you will be sponsoring for or that you will be sponsoring the foreign national for must reflect your minimum requirements or normal requirements for the position, and Julie will discuss that further. The PERM position also must be one where you are offering the prevailing wage as determined by the Department of Labor. You do have some options, and we're going to discuss that further, but overall, you must pay the prevailing wage as determined by the Department of Labor. And the PERM requirements also include the fact that the employer must maintain a PERM audit file for 5 years from the date of certification or from the date of a decision. And we help with all of that. We will help you put together the PERM audit file and also note how long you have to keep it. So in general, those are the PERM requirements, and I mean in general. There is a PERM labor certification memo that we share with all of our employers when we start the green card process, and it is boring and very detailed, but really worth it because it really outlines what you need to do in order to ensure that you are in compliance and your employees understand what the PERM requirements are. Because we get a lot of questions from employees regarding how long is it going to be, how long will it take, and they don't really understand the overall picture because they're not involved with the PERM process day to day, because we really discourage the foreign national being involved in the PERM process, actually. Again, it's about a fair test of the labor market, and you don't want to involve them if it could taint the fact that you're testing the labor market in good faith. So we're going to talk about in detail now drafting the PERM job description, because that is where we really need to partner with the foreign nationals manager and also the immigration professional. We can definitely give you a legal framework as to what needs to be done and what the Department of Labor requires, but in terms of what are your minimum requirements for the position to test the labor market with, we need that expertise to come from you. And Julie, you're going to talk about drafting the job description, right?
Yep.
Okay.
For those of you who've been involved in the PERM process before, you'll understand the significance and importance of the job description and requirements. They are the basis for the entire process. They affect the prevailing wage determination that the Department of Labor will make, and any applicants for the position will be evaluated based on those requirements. If there's an applicant who meets all of the requirements, we can't go forward with the PERM process. So initially when we start this, usually from HR to company, we'll get a generic description for the job. But for this process, generic just doesn't cut it. So we'll then have a conversation with an HR rep and the hiring manager so that we can get a detailed description of the daily duties and responsibilities for the position. We also need to know the minimum education required, including acceptable fields of study, how much experience is required, if there are special skills. This can be for the individual's current position or a future position. The PERM application should be filed for a position that the foreign national will hold at the time their I-45 application is approved. And as we've heard, due to visa backlogs, that could be many years. especially for Indian and Chinese nationals. So in those instances, you definitely want to consider filing the application for a future position. Once we have nailed down the description and the requirements, we have to confirm that the foreign national meets those requirements. And we also need to be able to document that. So we work with the foreign national, we show them all of the requirements for the position, we make them tell us how they qualify, and then we'll draft letters for them to obtain from their former employers confirming their prior experience and that they meet the requirements for the PERM position. Sometimes we can use employment in a prior position with the same employer to qualify for the PERM position if we can demonstrate that the two positions are not substantially comparable. And that simply means that the individual didn't perform the same job duties more than 50% of the time. One other consideration is if the employer has other individuals employed in the same position as the PERM position with really similar job duties. We have to make sure that those individuals also meet those minimum requirements. Let's see, when we start, or at the beginning of the PERM process, once we've done the job description and the requirements, we have to draft a prevailing wage request. So with that in mind, we have to consider how the job duties and the requirements will affect that determination. It's filed with the Department of Labor, and prior to filing that, we will look at the Department of Labor's online wage library, which is a compilation of various occupational classifications, each with 4 wage levels. So we try and determine what we think the Department of Labor will use for the prevailing wage for the position before we actually file that request. In addition, the requirements cannot be overly restrictive and they cannot be tailored to the foreign national's background. The prevailing wage request is filed, as I said, with the Department of Labor. The processing time varies. Right now, it's about 14 to 16 weeks. It's taking a very long time. So we also need to keep that in mind when we're starting this process. Various stages of the process have timing issues, and so we have to try and keep all of those in mind. When we look at that prevailing wage before we file that request, if we think that the Department of Labor will come back with a classification and a wage level that's higher than the salary being offered, there are some options we can look at. One of those is seeking an alternative salary survey, but we have to make sure that it meets the criteria established by the Department of Labor. For example, the survey data must be collected within the last 24 months. The data must be for the geographic area of intended employment, and there must be at least 3 employers and 30 incumbents for the position. Sometimes employers have in-house surveys or professional surveys that we might be able to use. We just have to make sure they meet the DOL's criteria. Let's see. If we go ahead, once we've made that determination as to what we think the classification should be and the job wage level, we file that prevailing wage request with the Department of Labor. Sometimes they come back with a totally different classification and a wage level that's higher than we actually want to work with. We still have some options in that instance. We can submit a request for a redetermination with an argument as to why we think the classification and level they picked is not suitable for the position, or we can revisit the position description and requirements and then file another request for prevailing wage.
Great. So we've gone through the process. We've drafted the job description. We've gotten the prevailing wage requirement. The next step is to test the labor market. And what does that mean? It means that the employer has to advertise, advertise by submitting ads for 2 Sundays. And we are still working with newspapers under the Department of Labor's real-world requirements. And then you also need 3 additional forms of recruitment from a list of 10 options that the Department of Labor has provided to us. And then also a posting in the state job bank along with a notice of filing. So essentially, the employer has to undergo through all of these recruitment efforts, and we really guide you, or your lawyer will guide you through the process of the test of the labor market. Again, this is a process where the foreign national should not be involved with the test of the labor market in order to maintain the integrity of the process. There's been cases about situations where it was determined that there wasn't a good faith of the test of the labor market because of the involvement of the foreign national worker. So that is why we want to maintain the partnership just between us and the immigration professional when you're doing a test of the labor market. For non-professional positions, you do not need to do the 2 Sunday ads, or you don't need to do the 3 additional forms of recruitment, and you just need to do the ads. Lauren, we've worked with you on many cases. Can you share with us what your experience has been with testing the labor market through the PERM process? Is it different from your normal recruiting efforts that you may conduct for other open positions?
I would say definitely it's very different, mostly because the Department of Labor has given lots of fun rules and language that we need to follow. So I pretty much 100% depend on Lon and the team to help us tell us exactly what we need. We've just learned in the past that, we can't even, every little detail has to be in these ads and things like that. And so the biggest difference is that with the Department of Regulations and their Department of Labor and their regulations, we just have to really depend on our legal team and making sure that we're following the steps and in good faith with all of that.
In terms of reviewing the resumes, though, do you treat the review of the resumes to determine whether the candidates are qualified? Do you treat it any differently when you review from other situations when you're reviewing for open positions?
I would say, yes, because we're looking at it in the terms of a specific position and what they're going to be doing within that. So I would say, yes, we do have to look at that.
And the reason is what I always share with our clients is that the PERM process is really an Alice in Wonderland process, even though to the Department of Labor it's real world requirements. And so in a PERM application, we are very specific, or we advise our clients to be very specific about what it is that they really require for this position, because we know in the real world you're trying to get as many candidates as possible to see what the pool is out there. But with the PERM process, you're trying to see if there are individuals out there who meet these requirements that you really need for this position, that for other positions you may not advertise because that's not determined until they walk through the door. And with the Department of Labor regulations, you just have to be very clear as to what the minimum requirements are for the position instead of being vague about it, as you may be for other positions that you have open. So once you do the test of the labor market, you have to put together the PERM filing, and that includes a recruitment report, all of the recruitment materials, newspaper ads, the notice of filing that's signed, the job bank posting. The Department of Labor is very particular about the fact that you have to make sure that you can document that you did indeed post a web advertisement for the time period that you've indicated on the job application, on the PERM application, I mean. And then if the position requires more experience than what the Department of Labor requires for the occupation, or more education than what the Department of Labor deems as being normal for the position, we also have the employer complete a business necessity letter to include in the PERM audit file, and we assist our clients with drafting the business necessity letter. But it's a process where compliance is very important, because if you are audited, we want to make sure that you have all of the supporting documents in your file and not have to gather it after the fact. So after recruitment is done, we put together the whole entire PERM file, and we want to make sure that we file no earlier than 30 days after the last date of recruitment and no later than 180 days after the first date of recruitment. So there is a time period that an employer has in order to file the PERM application. All right, so we're going to end with a discussion about promotions, transfers, and how it impacts the green card process. And we thought this was a really important topic to share with you because we get these questions all the time because of the visa backlogs. After we file the PERM application or the I-140 has been approved, you get notice from your managers that someone's been transferred to a different location or a promotion, or maybe there's termination discussions occurring. What are the consequences? And Julie, can you share with us briefly what are the consequences of some of these actions when individuals in the green card process?
Sure. If the PERM has been filed but it's not certified, need to move up, sorry. The employee has no benefit upon termination. If the PERM is certified and the I-140 is not approved, the employee still has no benefit from the certified PERM and cannot retain the priority date because the I-140 petition has not been approved. If the I-140 is approved but the I-45 is not filed, the individual can retain the priority date unless the I-140 petition has been revoked due to fraud or willful misrepresentation. If the individual finds employment with a new employer in H-1B status, they can also be employed in H-1B status beyond the 6-year limitation because of that approved I-140 petition, as long as it hasn't been withdrawn. If the I-140 has been approved and the I-45 has been filed, again, the employee can retain the priority date and be employed in H-1B status beyond the 6-year limitation. If the individual finds employment with a new employer in a position that's similar to the PERM position, they will also benefit from the pending I-45 application.
So if you didn't get all of that or catch all of it, that's fine.
I can do it
that's
again.
Why that's why we are here. But the whole point of it is that there are consequences to promotions and transfers and termination when an individual is in the green card process. And that is something for you to be aware of and also communicate to your team. And we now also get a lot of questions from the foreign nationals. Okay, we've gone through the PERM process, but I still have 8 years to wait for until I can apply for the green card because I'm from India. Are there any other options that you can consider sponsoring me for that could get me quicker in line or up the line for a green card? And that is what Deborah and Bob will be discussing with you now, permanent resident options, alternatives to PERM labor certification.